his daughter. See the lady in the front? Guy, she's right behind her in black. Long black hair.
Thank you.
All right.
Good morning, folks. Please be seated. Let me just say this at the beginning, at the outset. If anyone has a cell phone, and I'm sure everybody probably does, please disengage that cell phone at this time. Please disengage it. All right. The matter before the court is the matter of State of Ohio versus Matthew Cordle. And I want the record to reflect that Mr. Cordle was present with his two counsel, Mr. George Breitmeyer, who's to my right, and Mr. Matthew Marty Median. Present for the State of Ohio are Keith McGrath, and how come you look so much younger than Mr. O'Brien? I don't know. The color of the hair, I think. And Mr. O'Brien is here. The Franklin County prosecutor is here representing the State of Ohio. Now, this matter comes before the court this 23rd day of October for sentencing. Let me review a few matters. This matter came before the court September the 18th. And on September the 18th, the defendant was present with his counsel, same counsel for the State of Ohio, and the defendant, Matthew Cordle, before this court, entered a plea of two guilty. So let me identify the case number for the record. The case number is 13 CR 4732. And on that date in September, September the 18th, Matthew Cordle, the defendant, entered a plea of guilty to two counts. Count one was a felony of the second degree, aggravated vehicular homicide, a felony of the second degree. Moreover, Mr. Cordle entered a plea of guilty to count two, operating a vehicle while impaired, a misdemeanor of the first degree, in violation of 45-11-19. Aggravated vehicular homicide is a felony of the second degree in this state, and operating a vehicle while impaired, 45-11-19, is a misdemeanor of the first degree. The court on that date asked for a pre-sentence investigation. The court wanted the benefit of additional information so that I could make an informed decision relative to this sentencing. I asked for a pre-sentence report. Now, as always the case, in addition to the pre-sentence report, which I have reviewed thoroughly and received about a week ago, I received memorandums from the state of Ohio, sentencing memorandums. I received sentencing memorandums from the defendant, and I reviewed those. At the time of this court accepting the plea of guilty to those to the two counts just identified, I was informed that Mr. Cordle had on September the 3rd made a video wherein he acknowledged his guilt to the offenses that were here on this morning. And I was told that this video was placed on YouTube. I didn't have the slightest idea what YouTube was, but my secretary told me. It sounded like an outpatient procedure to me, YouTube, but my secretary gave me that information of what YouTube was. And since that was made, I have had the opportunity to view that at least 3 times. I viewed it initially, and then I wanted to go back and look at it again, and then I wanted to go back and look at it again, and I think the most recent viewing of that video was last Friday. That was the most recent time that I had viewed that video. Now, yes, gentlemen, please be seated. Please be seated. Some people have thought that that video that was prepared by Mr. Cordle was more about Mr. Cordle than the victim, Mr. Cancini. I don't think so. I don't think so. I think that this case is about a lot of people. Certainly this case is about Mr. Cordle, the defendant. He's 22 years of age. He'll be 23 on December the 25th of this year. This case is about the victim, Mr. Cancini. And this case is about all of you who come to this courtroom today, because this case impacts not only this gentleman, not only the victim, but all of our society. I firmly believe that alcohol and drugs are almost an epidemic in our society. Where Mr. Cordle is sitting now, where he was standing, no less than 65% of the people who come before this court, and I'm speaking for this court, no one else, no less than 65% of the people who come before this court and who plead guilty to a criminal offense are suffering with some kind of a substance abuse problem and or a mental health issue, no less than 65%. Now, I wasn't going to play this video today. I decided about 10 days ago I wasn't going to play it. I had seen it, I absorbed it, I discerned it, and I wasn't going to play it. Have it played in this sentencing. But I changed my mind over the weekend. And the reason I changed my mind is this. The state of Ohio, in its sentencing memorandum, wrote certain things that indicate that they feel that Mr. Cordle was not remorseful, showed no remorse for the victim, did not issue an apology. Mr. Midian and Mr. Breitmeyer, they take the opposite point of view, which is to be expected. They're representing different people. Mr. McGrath and Mr. O'Brien are representing the state of Ohio. They do not directly represent Mr. Consini, but they represent Mr. Consini's interests. And they should. This is a very serious matter. A very serious matter because it involves all of our society. And so what I have decided to do, for the benefit of you folks, is to play that video so that you folks, the public, will have an opportunity to see what I saw and what I discerned. Mr. O'Brien, on behalf of the state of Ohio, is there anything you'd like to say at this particular time?
May it please the court, the state filed a sentencing memorandum.
I read that.
And the court has the benefit of that. The court has the benefit of the pre-sentence investigation. Angela Canzani is here in court before the court would make a final decision on the sentence, but asked the court to...
I have read her statement. Is she here today?
She's here today, and I don't know if she wishes to read the statement or have the court just absorb the statement she submitted
Well,
to the court, but at least the court has the benefit of that.
I do have the benefit of it, and I did read it. I have read it. And if she wishes to speak, she'll be given that opportunity.
Okay. And I think the court has all the information available. I think much like the court indicated, the video that you're going to play here in court, when I first saw it, I was impressed by the message that the defendant was sending about not drinking and driving. I was impressed by his what appeared to be legitimate remorse for the crime. I think the point that I made, I didn't hear the words "I'm sorry," and that I think maybe the court was alluding to.
Well, I think that's...
in that video, although quite clearly he's expressing remorse, and the state acknowledges he was expressing remorse, and in the sentencing memorandum, I think he even indicated the obvious benefit for that expression when the court imposes a sentence. But I think the court has all the information to state, other than the statement from Angela, that the court would, the state would want the court to have in weighing the sentence that the court should impose.
Okay, I appreciate that. Mr. Median, do you wish to speak, or does Mr. Breitmeyer?
Your Honor, both of us would like to address the court if Mr. Breitmeyer may.
All right.
Thank you, Your Honor. I've had the privilege of knowing Matthew Cordle and his family for a number of years now. In fact, I can remember days when I used to help him with his math homework when he was in grade school.
I'm sorry?
I can remember days when I used to help Matthew with his homework back when he was in grade school. He's a graduate from Dublin Jerome High School, 22 years old, lives in Powell now. I heard about the
I'm
accident.
going to give you a chance to make a statement, but I want to proceed with the video at this time. So if you're making a statement relative to sentencing, I'm going to ask that you withhold that.
Okay.
Okay?
Yes.
Mr. Median, is there anything you'd like to add?
No, Your Honor, but I do have the video queued up.
Okay. Tim, if you dim the lights, I think it is time to see the video.
I was out with some friends. We were all drinking really heavily. Sobbing from bar to bar. Just trying to have a good time, and I lost control. You know, sometimes I drink because I have depression that I struggle with every day. And I just drink to get out of my head for a few hours. You know, I really don't like the person I become when I drink. I've ruined relationships in the past, start fights. You know, I just generally become a person that people don't like being around. And that particular night, I made a mistake and got in my truck, completely blacked out, and decided to try to drive home. I ended up going the wrong way down the highway, directly into oncoming traffic. I struck a car. I killed a man. Immediately following that, I consulted some high-powered attorneys who told me stories about similar cases where the drivers got off. They were convinced that they could get them a blood test thrown out, and all they would have to do for that was lie. Well, I won't go down that path.
My name is Matthew Cordle. On June 22nd, 2013, I hit and killed Vincent Canzani. This video acts as my profession. When I get charged, I'll plead guilty and take full responsibility for everything I've done to Vincent and his family. If I took a different route, maybe I would get a reduced sentence, and maybe I would get off. But I won't dishonor Vincent's memory by lying about what happened. Artists in this video, I know exactly what it means. I'm handing the prosecution everything they need to put me away for a very long time. But I'm willing to take that sentence for just one reason, and that reason is so I can pass this message on to you. I beg you, and I say the word beg specifically, I'm begging you, please don't drink and drive. Don't make the same excuses that I did. Don't say it's only a few miles, or you've only had a few beers, or you do it all the time. It'll never happen to you, because it happened to me. And all of those are just excuses to make yourself feel better about a decision that you know is wrong and could cost lives. I can't bring Mr. Canzani back, and I can't erase what I've done. But you can still be saved. Your victims can still be saved. So please.
Some people have felt that this matter was entirely focused on Matthew Cordle, and Mr. Cordle is the defendant, and it is focused on him. But having reviewed the materials that I have been given, let me tell you about the victim. The victim, Vincent Canzani, was 61 years old. He was a Navy veteran. He was passionate. He was a good man. And when he got into that car on June the 23rd, the accident happened about 2:43 in the morning. He never anticipated not making the destination that he saw it. He was struck head on by Matthew Cordle on I-670, a route that I've taken many times, a route that all of you have taken many times. He never anticipated not being here today, but he's not here. I received a letter, and I want to read this. This is a letter I received from the former spouse of Mr. Canzani, Cheryl Canzani Oates. Is she here today? Yeah. She's here today. And let me tell you something about Mr. Canzani so that you folks will have some information about him. I'm going to turn it from Mr. Cordle to Mr. Canzani. This is the letter I received from Miss Oates. I am Vincent Cansini's ex-wife. We were together for approximately 15 years. I believe that I am one of the few people that knew Vince better than anyone. Vince was the most passionate man that I've ever known. If it was an interest to Vince, he was passionate about it. One thing I can say about him is that he would never drink and drive. As a mother of 3 children, 2 sons, Vincent would tell my children that he would pick them up at any time, any day, no questions asked. He kept his promise. As I recall, one time, my oldest son called at 3 a.m. He was out with friends, about an hour away. I answered the phone, and I said I would be there as soon as I could. Vincent would not let me drive, even though he had to get up in 2 hours to be at work. Vincent said, I keep my promises. I believe that Matthew, these are her words, I believe that Matthew Cordle will also keep the promise he has made regarding drinking and driving. Let me tell you something more about Vince. Vince was an only child. His father, Joseph, was the president of Columbus College of Art and Design for 45 years. His mother, Vasa, was also a professor of art. They were passionate. So it is apparent where Vince got his passion. Vince would not want to see 2 lives lost in this terrible situation due to Matthew drinking and driving. Vince was forgiving and would not want to see Matthew sentenced to the maximum penalty. Vince always felt that if you learned something from your mistakes, then you were further ahead. I believe that Matthew is sincere in admitting that he took a man's life. Nothing will bring Vincent back, but I feel some good may come of this terrible situation that Matthew has created. I also feel that Matthew could ask for forgiveness from God, and he will be forgiven. My wish is that even though Vincent is gone, that once Matthew serves his time, he can move forward in his life and be a productive adult. I would also like to see Matthew speak to young men and young women regarding the risk of drinking and driving. She goes on. I would also like to offer my family's experience of a similar situation. And this letter was unsolicited, folks. In 1954, my father was 16 years old. He borrowed my father's car and picked up his best friend, Chuck. I won't mention Chuck's last name, but he picked up his best friend, Chuck. And they were double dating, my mother and her best friend. My father said he was inexperienced as a driver and said he was driving too fast. He was talking to Chuck, taking his eyes off the road, and he hit a bridge. The vehicle overturned in a creek. When my father awoke, he leaned over to Chuck and realized that Chuck was dead. My father made the decision then that with his children and grandchildren, he would talk to them and tell them the story of his best friend, Chuck. He gave the talk at age 16 to each of his children to each of his grandchildren. He has since passed, but on his deathbed, he told me that he never forgave himself, and that haunted him every day of his life. Her father died at age 64. I know from my father's experience what pain Matthew feels. The pain that he knows in his heart will stay with him until his own death, just like my father. And that was written by and presented to the court by Cheryl Kanzani Oates, the former spouse of the victim in this case. Early this morning, when I first got to this courthouse, early this morning, I received another letter. Now, some of you folks are not old enough to remember this incident. I am. I remember it well. This is a letter from a gentleman whom I have not met. It's a letter that came to me unsolicited. The writer of this letter is Harold Dennis Jr. And let me give you some background on this letter. In 1988, in the spring of 1988, the nation's worst drunk driving crash occurred on I-71, just outside Carrollton, Kentucky. I know the road well. I drive it regularly. On the side of the road, there's a sign. And that sign says, and it was in the spring of 1988, on this road, and it gives the date, in 1988, 27 people were killed by a drunk driver. I've driven by that sign many, many times. In fact, I just drove by that sign with my wife over Labor Day weekend. When I drove by that sign this past Labor Day weekend, I did not know Matthew Cordle. I did not know Mr. Kanzani, the victim, but I knew that sign, and I know what it meant. I want to share a letter with you that I received very early this morning. Harold Dennis is the writer of this letter. Dear Judge Vice, as a survivor of our nation's worst drunk driving crash occurring in Carrollton, Kentucky, and killing 27 people, I want to take a moment and write to you regarding Mr. Matthew Cordle. Let me preface this letter by stating that in no way did Mr. Cordle request that I write to you on his behalf, and in fact, he suggested quite the opposite. With that being said, I'm writing to you on my own volition. I obviously know firsthand the negative consequences that can result from a person's decision to drive drunk. 25 years ago, 1988, 25 years ago, I lost several friends, including my best friend, and suffered third-degree burns covering 25% of my body as a direct result of one man's decision to drive drunk. I, Harold Dennis, I was the victim. Drunk driving has created an enormous amount of pain and suffering in my life. And as a result, I have dedicated a major portion of my life toward educating young people about the dangers of this senseless act. Amidst all of my pain and suffering caused by one man's decision to drive drunk, the one thing that I found myself searching for was a simple acknowledgement from the very man that caused it. An acknowledgement of remorse and responsibility for his actions. 25 years later, I still find myself awaiting that acknowledgement, as he has yet to show it publicly or privately. This brings me to Mr. Cordle. In my humble yet relevant opinion, what Mr. Cordle displayed in his public confession, albeit unconventional, was not only the courage to surrender and take responsibility for his actions, but also a message of contrition to the family that he so tragically affected, and a very clear, direct message to others. Please do not make the same mistake that I did. Matthew's Cordle resonated with me, and in a strange way has given me what I waited 25 years to see and hear from another man. Despite how much Mr. Cordle serves, I sincerely believe that he has already begun to walk his path toward recovery, and that he will ultimately make a difference in many people's lives. And this was a letter from Mr. Dennis, who was involved in that terrible, terrible tragedy in 1988 outside Carrollton, Kentucky. Mr. O'Brien, I understand that you have a person or two that would like to speak to this court. I want to give you that opportunity to present that person at this time.
Thank you, Your Honor.
Yes, sir. Ma'am, I'm going to ask you to come to the podium. I'm going to ask you to elevate your voice. And the first thing I want you to do is give me your first and last name, and please spell your last name for the court reporter. Mrs. Irvin, please.
Angela Canzani.
I'm going to ask you to resonate that just a little bit more.
Angela Canzani, last name C-A-N-Z-A-N-I.
Good morning.
Thank you. Vincent Canzani was my father. He had 2 daughters and 5 grandchildren. My father was a man that had an impact on everyone he knew and touched the lives of many. He was a talented photographer and artist and enjoyed working out and being with people he cared about. My sister Marie and I will never see our father's face again. Our children will never see their grandfather again. We will never hear his voice. We will never hug him. And we will never look forward to another holiday with our dad, Grandpa. I've heard time and time again about a message, but the message I do not want to send is if you hit and kill someone, all you have to do is admit to it later and get leniency. I hope Matthew Cordle does raise awareness after he does this time, and does it sincerely by going to schools, etc., not publicly. My father got a death sentence and did nothing wrong. 8.5 years is nothing. Less than that would be unjust. After 8.5 years, Matthew Cordle will still have his whole life ahead of him. My dad is never coming back. Thank you.
Thank you. Mr. McGrath, is there anyone else that you wish to have speak to the court?
No, Your Honor.
Right. Mr. Breitmeyer, Mr. Midian, is there anyone that you wish to have speak to this court, please?
Yes, sir, Your Honor. Matthew's father, David, would like to make a statement.
Okay.
Would you like to come up to the podium?
Mr. Cordle, if you'll come forward. It is Mr. Cordle, correct?
Yes, sir.
Sir, I'd like for you to give us your full name, and for the record, please spell your last name.
My name's Dave Cordle. Last name Cordle. I was doing pretty well until you played that video.
I'm sorry?
I said I was doing pretty well until you played that video. It gets me every time. I am Dave Cordle. Matt Cordle is my son. His mother, Carrie, his sister, Sarah, Grace, Paige, brother-in-law, E-Care, my wife, Ellen, and I are here to support Matt and your decision, Judge Feist. All of us are deeply saddened by the horrific events on June 22nd, the night Vincent Canzani was killed. I am very disappointed, disgusted, and heartbroken in the choices Matthew made that tragic night. Choices that have changed two families forever. It has been very difficult, but I've seen my boy turn into the man who stands before you, willing to accept full responsibility and the punishment this court feels is just. This is not about glorifying Matthew or to get a lighter sentence. No, it's simply to do the right thing and honor Vincent Canzani's life by speaking the truth and sparing the Canzani family the ordeals of a trial. I believe my son's mission in life will be to spread and share this tragic experience with as many as possible to change others' attitudes and spare them the consequences of Matt's fate. If Matt can save just one victim, like Vincent, then Matt truly knows his time incarcerated will have been beneficial. I cannot begin to tell you how many letters, text messages, Facebook postings, and phone calls we have received in response to Matt's message. Complete strangers have made contact sharing their stories and were so moved by Matt's message that they also made the promise to never drink and drive again. To Angela and the Canzani family, my heart is filled with sorrow for your loss. I cannot express enough our deepest sympathy for the pain and anger you must feel. My hope is someday soon you will be able to overcome this tragedy, find peace of mind, open your heart, and begin the healing process, and then and when you are able to, forgive my son Matthew. Thank you.
Thank you. Mr. Breitmeyer, anyone else that you wish? I'm sorry?
I don't think there's anyone else, Your Honor, other than Mr. Medina and myself.
Who would like to speak on behalf of the state relative to sentencing? Mr. O'Brien, please.
Thank you, Your Honor. May it please the court. The court's well aware of the statutory guidelines to impose a sentence in a case like this, and while the court has the parameters of 2 to 8 years, it's the state's view that the facts and the facts that occurred back on June 22nd and the facts that are shown in the pre-sentence report before that day, that the court, in considering, should be on the high end of the parameters of 2 to 8 years. It's the state's position, as the court again is well aware, that one of the statutory guidelines is to look at sentences in similar cases, and so we tried to provide that information to the court. And the one case that did stand out to us was a fairly similar case, although there wasn't a chemical test, where a man went left of center, and the court imposed back in May a 6-year sentence for aggravated vehicular homicide. And it would be the state's view that the court in that range of 2 to 8, using that as kind of a guideline, should be in the area of 6, 7, or 8 years for the aggravated vehicular homicide, and as indicated in the sentencing memo, that as a misdemeanor, the state would believe the court should run that concurrent with the felony, acknowledging the general statutory rule that misdemeanors are to be run concurrent. And unless the court would have any questions, Sergeant Brooke Wilson from the CPD Accident Investigation Squad that investigated this accident is here in court. Should the court have any questions for him, he did bring the ODOT video with him that shows about 11 seconds of the defendant traveling the wrong way on 670. You can't see actually the collision. The state didn't think it was necessary either to present at the plea or today, but if the court would want to see that, that's available. But I think the court has all the information the state would want the court to have, and certainly Mr. Midian and Mr. Breitmeyer, who have done a good job in an excellent case, will present the other information to the court that you should have before you making that tough decision with a broad range of years to impose in this case, which of course is mandatory.
And
So unless the court has questions.
I don't have any questions. This accident occurred, of course, at about 2:43 in the morning on that date. Nearly 2 other cars were involved as well. They fortunately were not injured. They averted the accident. And I will note, I think this should be noted, that there was a blood alcohol test, and that was not voluntarily given. That was a test that was secured through a search warrant obtained from a judge in municipal court as a result of that blood alcohol test, the results of which were 1900s, a little over 1900s of 1%, which of course is twice the legal limit.
That's correct.
I want to make sure that's clear on the record.
That's correct, Your Honor.
But also let me make this observation. No case is like another case. Every case is different. And if we as judges, could just push a button and say this happened, this is the penalty, then there would be no need for the 17 judges on this court. Each judge must make an informed decision based upon the facts presented to him or to her. And every case is different. There's no case that's the same. Anything else?
No, Your Honor.
Thank you, sir. Now, both of you appear to be wanting to get up at the same time.
Yes, sir. If I may first, and then I know Mr. Midian's got some comments he'd like to make.
Okay, Mr. Breitmeyer.
Your Honor, as I was saying, I've had the privilege of knowing Matthew and the Cordle family for a number of years. I can remember days back when Matt was in grade school and I was helping him out with his algebra homework. I heard about the accident the day after it happened, and I was as shocked as anybody to hear that Matthew had been involved in such a horrific accident, making such horrible decisions to drink and drive and ultimately take the life of Mr. Gonzani. Despite the state's contention that the case was a slam dunk, there are always ways to present a defense. No case is actually a slam dunk. However, after meeting with Matthew on a number
I don't know what you mean by a slam dunk.
A slam dunk. The state's contended at certain points throughout this case that it would have been unbeatable. There would have been no defense offered that we could have won. And my point in bringing that up, Your Honor, is that Matt didn't choose to explore those options. Matt didn't want to use technicalities that were buried within the law to try and beat the case. He came to us with the arrangement that he wanted to enter a guilty plea and not vigorously litigate the case. He'll be the first person to tell you that choosing to drink and drive on the night of June 22nd was the worst decision he ever made in his life. And unfortunately, Your Honor, in our line of work, both the court, the state, and defense counsel is aware of many of these types of tragic events that come in all different shapes and sizes. What we're not as familiar with is how people handle or react to making these horrendous decisions. Unfortunately, or fortunately for Matt, Your Honor, he turned himself in the day of the indictment. He had the ability to post bond but chose not to, and he instructed us to get in front of the court at the earliest conceivable time so that he could fulfill his promise to plead guilty at the earliest time the court would allow. There are a couple small points I'd like to point out that the state referenced in their sentencing memo. One was that Matt never apologized to the victims. Matt, in fact, did write a letter to the victims prior to his indictment, prior to being charged, prior to being arrested, and I believe it was relayed through counsel for the victims, not the state, but other counsel for the victims. An apology note that Matt wrote was given to the victims, so he did apologize. He just didn't feel it was meant for a public apology and wanted to direct that directly towards the victims. Also, with respect to the YouTube video, Your Honor, that's had such a large presence in the case, In releasing it, Matt has always said that he had two purposes doing it. One was to raise awareness about the risks associated with drinking and driving, put a face to the problem, show that it can happen to anybody. His second purpose in the video was to let the Kanzani family know and hopefully allow them some closure, saying, "Hey, look, I'm not gonna present a vigorous defense. I'm not gonna litigate the case."
Let me just stop you right there.
Yes, sir.
Mr. Breitmeyer. In a case like this, there will never be closure. Never be closure. These people, Mr. Cordle, and these folks will live with this case the rest of their lives. There will never be closure.
Absolutely, Your Honor. I guess I misspoke. Just to let the victims know he didn't intend to litigate the case out for a year. That was the purpose of him creating the video. Up until yesterday, Your Honor, Matt was hesitant about the video even being played today at the sentencing hearing. It was after conversations we had with the court, the state defense counsel, that we did all agree and feel that it was appropriate due to the prevalence in the case, Your Honor. I just wanted to let you know that it wasn't Matt's original intention to do it. It wasn't until conversations we had with Matt in the past few days. And with that, I know Attorney Midian has some statements he'd like to make as well.
All right, Mr. Midian, please.
Thank you, Your Honor. When the legislature classified the penalties for this particular crime, they no doubt envisioned a situation where a maximum sentence would be warranted. I'm certain, Judge, that they envisioned an individual with a lengthy criminal history, multiple convictions for OVIs, and a general disregard for the safety of others. But at the same time, Your Honor, the legislature certainly envisioned a situation where a sentence at the low end of the spectrum would not only be fair and appropriate, but the right thing to do. I'm certain, Judge, that the legislature envisioned a man like my client, Matthew Cordle, a person with no prior OVI convictions, minimal criminal history, positive outlook on life, and most importantly, Judge, the appearance of a young man who made a mistake. Now, the court has been given a great deal of discretion in this case by the legislature. And I believe they did that, Your Honor, because they knew that you would be the best person situated at evaluating this young man, at taking a look at the character and integrity that he has shown in the face of overwhelming adversity. But Judge, the legislature gave you a lot of authority, but at the same time they took away a little bit. As the court is aware,
The legislature always does that.
they do, Judge, sometimes to their detriment. But they took away the ability for you to grant judicial release in this case. And I'm sure you're aware that the sentence that you imposed today, Matthew will serve day for day with no chance of early release.
And Mr. Cordle also, because of the nature of the offense of vehicular, aggravated vehicular homicide, faces a lifetime suspension of his driving privileges.
That is correct, Your Honor. And I believe that is the least of Matthew's concerns today. But he does appreciate.
But let me also, you mentioned why I'm familiar with Mr. Cordle's record. And this is his first conviction for operating a vehicle while impaired.
Yes, it is, Your Honor.
But I've read the statistics, and you've read the statistics, and Mr. O'Brien has read the statistics, that a person who is arrested and convicted of OVI probably, more often than not, has probably, and if I were to ask Mr. Cordle this, has probably driven under the influence or impaired probably multiple times. I've seen the statistics 80 to 100 times. This was the first time that he was arrested as a result of a tragic accident. So I'm sure this is not the first time that Mr. Cordle, and I think he even admits that he has driven and drunk alcohol numerous times while impaired.
Your Honor, I would agree with the court, and Matthew was very forthright in his pre-sentence investigation interview. But unfortunately, Judge, and I've seen this, and Mr. Breitmeyer has seen this many times in the clients that we've represented over the years, it sometimes takes an eye-opening experience for people to realize the error of their ways. And I know I've represented hundreds of people in municipal court on the basic OVI offense. And I would say 90% of them, Judge, I never see again. They learned their lesson after that first offense. It was very unfortunate that Mr. Cordle's first offense resulted in such a tragedy. But Judge, when we were first retained to represent Matthew, and I believe Mr. Breitmeyer alluded to this, it was under the express condition that we offer no defenses to the charges. Our role was simply to merely help him.
You have a professional responsibility to represent this gentleman. I want to make sure it's
It is very clear, Your Honor.
that you have a responsibility to represent him effectively and professionally. And I want to make sure that you have done that.
Yes, we have, Your Honor, diligently as well. But Mr. Cordle wanted us to help him plead guilty. And as time passed, Judge, he realized that he had a hard time waiting for his day in court. He was overwhelmed with guilt. The letter he sent wasn't enough. He knew that he needed to do more. So he chose to do something that most young people do in this day and age, is he turned to the internet and he made the video that we've all seen in court today, where he accepted responsibility for his actions, promised to plead guilty, and begged others not to make the same mistake that he did. And Judge, we'll never know the full impact this video has had upon society. But what we can tell you today is that it has been viewed by over 2 million people and reported on by media outlets around the world. So what that means, Judge, is that the sentence you impose today is going to reach far beyond the four corners of this courtroom. It's going to reach out to the world, and it will hopefully send a message to them, to everyone around us, that if you make a mistake, it is okay to admit when you're wrong. It's not going to be worse if you stand up in the face of adversity and say, I'm sorry. Judge, can you imagine a society where instead of people running from their mistakes and hiding, they owned up and said, I did it? I know, Judge, that's a bit far-fetched to imagine in this courthouse today, but I think a lot of people could learn a lesson from the example that Matthew has set. And Judge, I hope, it is our hope that the message that Matthew put out to the world will last far beyond the sentence that you imposed today. But in the meantime, can you imagine, Judge, this video being played at halftime during the Super Bowl, or before Game 7 of the World Series, where millions
Well, usually, Mr. Meddy, let me just stop you right there. Usually at the halftime of the Super Bowl, they're running a beer cooler.
My point precisely, Your Honor. This is an event where millions and millions of people will be watching, and many will be drinking.
Absolutely.
But bring it a step closer to home. Can you picture two parents sitting down with their teenage son or daughter, pulling up this video, watching this video, teaching them about the dangers of drinking and driving? And Judge, it's a tragedy that this horrific event had to occur in order for us to have this realization. But what Matthew has done today is transcend the tragedy. He found a way to take a terrible situation and make it a little bit positive. And if his message can save 1, 2, 3, maybe 100 lives, Mr. Canzani's loss will not be in vain. And Judge, just as Matthew cannot bring back Mr. Canzani as much as I know he would like to, the court cannot impose a sentence that will bring him back either. In fact, I know that Matthew would gladly trade places with him right now if he could. And not long after the incident, Matthew had thoughts of suicide. But he quickly realized that that was the coward's way out. And that the only way to ever truly make amends for what he did was to accept responsibility for his actions and live the remainder of his life in honor of Mr. Canzani. Your Honor, just as there is no computer that can tell the court and the world how sorry Matthew is, there is no mathematical equation that can factor in this case and come out with the appropriate sentence. There's simply too much humanity involved in this case in order for it to be determined by a calculator. And that's why, Judge, the legislature gave you the discretion that you have. Because they knew that they needed a person with courage and compassion to properly analyze all the factors in this case, sift through the emotion and the guilt, and arrive at the proper decision. Judge, I'd ask you to
Before you
Yes,
go
Judge.
on, I'm going to let Mr. Cordle speak. But you know, in about 4 or 5 weeks, we'll be nearing the holiday season, Thanksgiving,
Yes,
Christmas. And you can drive throughout this county, any part of the country, and you'll see large billboards. And on these billboards, they'll be advertising your favorite alcoholic beverage. What I would like to see is a billboard that says, "I'm Matthew Cordle. I pled guilty to OVI, aggravated vehicular homicide. I was sent to prison. I drove drunk. I killed a man. Don't drink and drive." That's what I'd like to see.
I think Matthew would be okay with that. He's done a purpose.
I understand. I'm just making the observation. Because everybody, not everybody, but so many people in our society draw parallels between celebrations, whether they be birthdays. And I think on this particular night, if I recall, Mr. Cordle was celebrating a cousin's birthday, correct?
Your Honor, the cousin's birthday, who he was celebrating, was a 12-year-old cousin of his.
Okay.
That's a mistake.
But so many people draw parallels between celebrations, baptisms, holidays, birthdays, anniversaries, and alcohol. They pull them together.
Judge, if I may briefly wrap up my allocution. We're not going to ask the court for a specific sentence because, frankly, that's not our job, that's yours. But what we would ask you to do is take one last look at Mr. Cordle and take my word for it, Judge, when I tell you that you've never had an individual before your court who's more sorry for what he has done than Matthew is. And with that, Judge, I would ask you to impose a fair and appropriate sentence. Thank you.
Thank you, Mr. Cordle. I will tell you that you've been well represented by both your counsel. I want to ask you this question so it's clear on the record. Are you satisfied with the legal representation you received from both your lawyers? Are you satisfied with that legal representation?
Yes, Your Honor.
Okay. Mr. Cordle, I'm going to give you the opportunity to make a statement to the court before I proceed with the responsibility that I have.
We're here today to discuss what happened on June 22nd, not what followed. Whatever my sentence may be, there is no such thing as a fair sentence when it comes to the loss of a life. The true punishment is simply living. Living with the knowledge that I took an innocent life, that I irreparably damaged the lives of Vincent's family and friends, and that pain and weight will never go away. As stated before, my apology to the Canzanis was made privately. However, I would like to take this opportunity to apologize in person for my horrible crimes. To the Canzani family, to Ms. Cheryl Oates and her family, I'm so sorry for the pain I've caused you, for the loved one I've taken from you. It should have been me that night, the guilty party, instead of an innocent man. With that knowledge and carrying that weight, I vow that I will do everything I can to prevent this senseless loss of life and prevent more innocent families from experiencing the pain that you are feeling now. I will not let Vincent's memory fade. Thank you.
Anything else?
No, Your Honor.
I'm going to proceed with sentencing. And before I proceed with sentencing, I just want to say this. I read a letter from Mr. Dennis, who was involved in that terrible, terrible tragedy on I-71 just outside Cordle, Kentucky. And when I drove by that sign this past September, I didn't know you, Mr. Cordle. I didn't know Mr. Canzani, and I didn't know Mr. Dennis. But the next time that I drive that patch of road and I see that sign, there are 3 names that I'll remember. Mr. Canzani, Matthew Cordle, and this gentleman, Earl Dennis. And that sign will resonate with what happened in this courtroom, this date. As I said, there is no magic number. There's no magic sentence. I reviewed all these matters as thoroughly as I could. And I've been doing this now for 25 years. And the hardest part, the most challenging part of any judge's job, responsibility, is imposing a sentence. And if there's any judge in this court or any other court who derives pleasure or gratification out of imposing a prison sentence or a jail sentence on anyone, regardless, if that person gets gratification or enjoyment out of that, then that person should not be on this bench. It is a responsibility, a high responsibility, and I take that very seriously. And I want you to know that. Now, relative to sentencing, I'm going to proceed with 13 CR 4732. What is the jail time credit, gentlemen, on this case?
45 days, Your Honor.
We stipulated 45 days.
45 days. Now, my sentence is going to be as follows. I'm going to impose sentences on both counts. And let me explain to you why. I think there needs to be an explanation. I'm going to impose a sentence on count 2, and I'm going to impose a sentence on count 1. And those sentences will run consecutive, and I'll tell you why. I think it's appropriate to impose a sentence on the OVI because the OVI is the genesis of why we're here today. Had Mr. Cordle not been driving that vehicle on that early morning under the influence, we wouldn't be here. The sine qua non, and for those of you who do not take Latin, is that for which not, is the OVI. So relative to count 2, the court imposed a sentence as follows: 6 months to the Franklin County Correctional Center. The court imposes a fine of $1,075 in the court costs. Pursuant to the statute, the driving privileges are suspended for a period of 3 years. That pertains to count 2. The court has imposed a sentence of 6 months to the Franklin County Correctional Center. Now, relative to count 1, count 1 is the offense aggravated vehicular homicide, a felony of the 2nd degree, 2903.06. The court imposes the following. The court imposes a sentence of 6 years to the Ohio Department of Rehabilitation and Corrections, a sentence of 6 years. The driving privileges, it's a lifetime suspension. The court costs are imposed, and the court is going to order that counts 2 and 1 run consecutive. The court has, for all intents and purposes, imposed a sentence of 6.5 years. Now, the order of the court is this. Mr. Cordle is to satisfy the 6-month sentence in the Franklin County Correctional Center. I'm going to award the jail time credit on that count 2. The jail time credit will be awarded on count 2, and after he completes that sentence, he'll be transferred to the Ohio Department of Rehabilitation and Corrections, where he'll complete the sentence of 6 years. I'm going to also order that the court costs on both cases and the fine that was imposed be deferred. Be deferred, not suspended, but deferred until Mr. Cordle is released. Mr. Cordle, I want to advise you that having imposed that sentence relative to the felony, after you're released from prison, you will, it's mandatory because that's the statute, you will have a period of post-release control for a period of 3 years. If you violate a post-release control sanction, any one of the following may result. There are 4, and they are as follows. 1, the parole board a more restrictive post-release control sanction. 2, the parole board may increase, lengthen the duration of the post-release control subject to a specified maximum. Thirdly, the more restrictive sanction that the parole board may impose may consist of a prison term provided that the prisoner cannot exceed 9 months and the maximum cumulative prison term so imposed for all violations during the period of post-release control cannot exceed 1/2 of the stated prison term originally imposed upon you. Lastly, fourthly, if the violation of the sanction is a felony offense, you may be prosecuted for the felony offense, and in addition to any sentence it imposes on you for the new felony offense, the court may impose a prison term subject to a specified maximum for the violation. Do you have any questions?
No, Your Honor.
Some people will think that that sentence was too lenient. Some people will think that that sentence was too harsh. This court has reviewed this matter thoroughly, and the court feels that the sentence just imposed is the appropriate sentence. Good luck, Mr. Cordle.
Thank you, Your Honor.
And good luck to the consent. This case is concluded.
Thank you, Your Honor.